Hello, everyone. It is so exciting when you're expecting your child. You decide if you want to find out if you're having a boy or girl. You debate names, you consider room colors and furniture. You study endless reviews and safety features of cars, car seats, strollers. You find out about childcare options or work out a budget so you can stay home with your child. After all that, don't forget what might be one of the most important things to consider for your child's long-term welfare: estate planning. Today, I'm going to talk about what you need to do in estate planning now that you are a parent. If you don't make a plan, the court, that means the state, will do it for you. So don't leave your child in the hands of the government. I'm Raluca. I offer estate planning, family law, and immigration services to my clients. And I'm here with my office and marketing manager, Nina Clear. Thank you for all your likes and shares and comments. And we really appreciate all your support as it helps others to see our videos.
And maybe the first question people ask is, when should you start estate planning for your child?
I would recommend that you and your partner discuss estate planning while you are pregnant and set up an appointment with an attorney prior to giving birth.
That seems really early.
Well, if something happens during the birth, you want to have a plan in place, right?
Yeah, usually. So what things should you discuss with your partner?
I tell my clients there are 3 things they need to decide. That is, who can and should care for the child, who should handle the property and business of the estate, and who will handle the child's property until they are old enough to do so.
Can you break it down a little bit on each one?
Sure. In terms of who can care for your child, you want to consider if the person has the same beliefs as you and will raise the child as you would like. Also, you should pick someone who can afford to take care of your child.
Do you think you should ask the person that you pick?
Definitely. Someone can refuse to be a guardian even if appointed in your will, so don't let this be a surprise for someone. Plus, you might want to talk to them about what you hope for your child and how things go in your house. Hopefully, your child knows and has a relationship with this person as they grow.
Okay, so moving to the second question that you said you have them consider, do you, would you not have the co-parent handle the business and property of the estate?
You may or you may not. You know each other best. You know who is good with money or who might be better if someone else handles that. Again, open discussions and clear written out instructions are what work best in estate planning. A wish, not written down, is just a wish, not a guarantee it will happen.
And with the last part, who will handle the child's property, that could be the same person as who handles the estate property, right?
Yes, it could be, or you could designate a different person. Keep in mind, if you die and leave money or belongings to your child, they receive that when they turn 18. Some people also want to appoint a trustee until their child is older than 18, so this might be something you need to consider.
Now, why would you appoint a person, 2 different people, one as a guardian and one as a trustee or manager of the estate?
Well, a guardian cares for your child and makes decisions about their life, but the person who handles the money might need to be a different person. It's really up to you to decide based on what is best for your child.
And I've heard some attorneys recommend naming a testamentary guardian and a standby guardian for your child in your will. Can you explain what those are?
Sure. Testamentary means something that is part of your will. So make sure that you put in your will who you want to care for your child.
And what power does a testamentary guardian have?
They are first in line after a parent to petition the local probate court for guardianship of the child.
So that's interesting. It's not automatic.
No, but courts try to move quickly so the children or the child can have stability.
And then what is a standby guardian? Is that someone who goes in place of the testamentary person?
This is someone who steps in usually while you are still alive, but unable to care for your child and has legal authority to care for your child.
Is this something that you put in your will?
Well, a will doesn't go into effect until you die, so this is done a little differently. It certainly would still be part of your estate planning that you should do with an attorney, but this is a specific document that Georgia requires, and it's called a designation of standby.
And you said it gives custody of your child to a person?
Yes.
Is that permanent?
No, the probate court can grant custody for up to 4 months if the parents have filled out a designation of standby form. Anything beyond the 4 months must be filled with the court.
And when would you use that standby?
In Georgia, it can only be put into effect if a physician has said a parent is unable to care for a child because of incompetence or debilitation.
Why would you use that?
If the parent were incapacitated, let's say they had a terminal illness or were in a coma, but you didn't want to have their parental rights terminated, this will go into effect. They basically share custody and decision-making power with the standby guardian.
And does that happen automatically when the parent becomes incapacitated?
No. The form that was filled out by the parent when they were mentally competent, but it must be filed in probate court and a judge must okay it.
And do both parents have to agree to it?
Yes. In Georgia, if both parents are alive and haven't had their rights terminated, they must agree to the standby guardian.
Do you recommend that family is chosen as a guardian?
Well, this is really up to each person. Many people don't recommend that the grandparent be listed merely because they can be older and might not be around for the child's life. But that is a personal decision for each parent to determine what is best for their children.
Okay, so what else should a person consider as a new parent or almost new parent when they're doing their estate planning?
Just as with any estate planning, you should be sure to have healthcare directives and a power of attorney written up as part of your estate plan.
And is there anything else that you think is important as a new parent?
I think it would also help ensuring that you have enough life insurance.
And how do you determine what's enough?
You have to look at what might be needed to pay off a mortgage, pay for a child's care and schooling, and provide for necessities of life.
So typically your spouse is named as your primary beneficiary on life insurance. Would you recommend naming the child as the secondary beneficiary?
In a roundabout way, I would actually name the estate as the secondary beneficiary.
Okay, anything else?
Yes, it is much more likely that you will become disabled in your life than die. Therefore, you should also look into disability insurance for yourself to help you care for your child if you are not able to work.
What about if your child has a disability or special needs?
I recommend putting a special needs trust in place. This should be done for someone who is receiving Social Security, Medicaid, food stamps, or any type of public assistance due to a disability. The nice thing about this type of trust is that in Georgia, there is a yearly review by the state of Georgia's Department of Community Health to ensure that trust monies are being used specifically for the benefit of the child.
And along with making a plan as a new or almost new parent, anything grandparents should do?
Well, that's a great reminder. If you are a new grandparent, don't forget to have your estate planning reviewed by an attorney so that your grandchildren are included in any plan you currently have in place. Also, keep in mind all of these things we recommend for parents, which they are all things that we recommend for parents with children of any age, especially if you have no estate planning in place at this time. Thank you so much for watching. And if you have any questions, please reach out to us for a consultation. And hi to Mariana and Claudia. We'll see you tomorrow.